Let's speak to the victim's lawyer in the Uhuru Kenyatta case, and that's Fergal Gaynor. Thank you so much for joining us this evening, Fergal. What's your reaction to these latest developments?
Well, I think the victims will be relieved the appeal succeeded, then that this issue is now back to the trial. It's very important that we hear from the government of Kenya whether they are now serious about cooperating or whether this is simply another chapter in what has been a long story of obstruction of justice by the Kenyan government.
So do you feel that there could be a chance that we might see some very different things happening after this?
It's very hard to tell at the moment, but certainly it's clear from what the appeals chamber said today that Kenya's duty to cooperate remains. It remains under a duty to hand over the financial evidence, to hand over the mobile telephone evidence that was at the heart of the litigation before the trial chamber. That duty hasn't gone away. We know that under the Constitution of Kenya, the person who is required to ensure that Kenya fulfills its international obligations is the President of Kenya, and that hasn't changed either. So President Kenyatta remains under a duty under the Constitution to ensure that Kenya fulfills its obligations, and that includes handing over the mobile telephone evidence, the banking data, and other information which has been withheld from the court for several years now.
And if that response from the Kenyan government is not necessarily as cooperative as you might hope, do you think there is a chance that Kenya might be referred to the Assembly of State Parties?
It's going to be interesting to see how the trial chamber handles that. It will no doubt hear submissions from the prosecution, from the government of Kenya, from the victims, I would expect, as to what is the best means of securing Kenya's cooperation. What the appeals chamber made clear today was that the most important thing is to ensure Kenya's cooperation. How that is achieved is up to the trial chamber to decide. But one thing that is not an option is for Kenya to continue not to cooperate and for there to be no consequences. There must be consequences for Kenya's continued non-cooperation in this investigation.
All right. Well, one of the things the appeals chamber did note is that there were factual errors in how the trial chamber handled Bensouda's application. But also there's a different application that you made regarding how the prosecution handled this case. How does this affect that?
This is tied into it because one of the allegations that we've been making is that the prosecutor didn't try hard enough to secure Kenya's cooperation by using Article 87.7. So the prosecution has now had its first Article 87.7 application sent back to the trial chamber. That should not prevent the prosecution in any way from continuing to bring as many Article 87.7 applications as are necessary to make sure that the trial chamber and everyone else understands the full extent of the non-cooperation by the government in this case. And it's a campaign of non-cooperation which has taken place, of course, alongside an international campaign by the government to discredit the ICC, to vilify the ICC. That campaign has gone on, as you know, before the African Union, before the UN Security Council, and before the Assembly of States Parties. So we will head back to the trial chamber. It will no doubt hear from all interested parties and participants, and then it will make a decision in due course when it's heard from everyone.
All right. Thank you very much for making time to speak to us tonight, Fergal. That was Fergal Gaynor. He is the victim's lawyer in the Uhuru Kenyatta case at the ICC.